One of the questions I'm often asked is, what relationship does psychology have to criminology, or psychology to criminal justice? And the answer to that question is that psychology and criminal justice are like two twins that were born together, separated at birth, and decades later found out that they're living on the same street, they work in the same building, and they're doing almost the same type of task. And that's because what criminal justice pays just as much attention to psychology, if not more, than psychology does. Because what determines whether or not someone is guilty of a crime? It's obviously whether they factually committed the crime, but the law takes great pains to apportion blameworthiness, that is, just how guilty you are, just how responsible you are, by trying to infer what was in your state of mind when you committed that crime. And let's take homicide as an example. Homicide simply means the killing of one human being by another human being. Homicide, in its pure definition, is not even a crime. It's the way the homicide is committed. For example, there are types of homicide that are not a crime. There's something called justifiable homicide. If someone is attacking you and you're in fear for your life and you defend yourself, then you have committed a crime. You have committed an act of homicide. You have one human being killing another human being, but it's not a prosecutable crime. If you're driving down the road and somebody jumps into your way and there's no way you could have avoided it, that's an accident. That's called an excusable homicide. Why call it a homicide? Because it's a killing of one human being by another. Okay, it's not a crime though. But that's not usually what comes to attention either in the legal system or in the media. We have several levels of homicides. For example, we've all heard of the difference between murder 1, murder 2, manslaughter 1, manslaughter 2. Why are there so many categories? Why does homicide have such a long menu? The reason is because the sentences that a judge passes out and the blame, based on the blameworthiness that we attribute to the defendant, is based on nothing less than a jury's inference of what was going on inside that defendant's mind. So let's take murder 1, first-degree murder. First-degree murder means that you have committed a homicide with both intent, with malice, and with premeditation. And what that means is not only, if I commit homicide, not only did I intend to kill that person. What does that mean, intend? It means at the time I pulled that trigger, made that blow, made that stab wound, whatever the method was, had my hands around the poor victim's neck, strangling them, I was intending to cause their death. What are you saying, as opposed to what? We'll get to that. But there's more. In order for it to be first-degree murder, I have to have planned ahead of time to kill that person. The question is, how much planning do I have to have? A year's planning? A day's planning? A second's worth of planning? That's why the law gets interesting. Because if a prosecutor wants to pursue a case of first-degree murder, he has to convince a jury that there was some reasonable interval that the defendant had to consider whether or not to do that crime, and nevertheless committed that homicide. That's first-degree murder. That's the most blameworthy and the offense, which if there's a death penalty, will usually get that death penalty. If not, they'll get the longest non-death penalty sentence. But that's distinguished from second-degree murder. In second-degree murder, there's what's called malice, that is, intent. In other words, I intend to kill you. But it's something that arose in that moment. We're having an argument that explodes into violence. I still intended to kill you, but it's not something that I planned. So again, imagine 6 or 12 jurors who are not psychologists. This would be a thorny issue even for trained clinicians to figure out. But you're asking 6 or 12 citizens to decide in their mind at what was this defendant planning, was this defendant not planning. Now, some of it's going to be based on the evidence. For example, if the defendant went around several days before the crime saying, I'm going to kill that person, then that's pretty good evidence that the person was planning it. You don't have to infer anything. The person, unfortunately for him, broadcast his intent to commit that crime. But in other cases, it's not so clear. In manslaughter, there is intent to kill the person, but there's an absence of malice. Malice means a hateful or deliberate intent to commit harm on that person. And that's considered less blameworthy still, because even though I clearly killed you, it wasn't due to any ill will or animosity towards you. Well, then why did I kill you? It could have been just an argument that broke out. It could have been something that occurred during the commission of another crime. For example, I come in to rob a store, and I point the gun at you. And as a store clerk, this is your business, this is your livelihood. You see your whole savings wiped away. You don't know what to do, so you grab the gun. A scuffle ensues, and the gun goes off. All right? I may be prosecuted for a number of different crimes, but it might not be murder. It might not be murder because I did not go into that encounter with an intent to kill you. I intended to rob you, and the prosecutor is certainly going to highlight the callous and indifferent way that I approached human life, but there's no intent there. And finally, that would be voluntary manslaughter. Involuntary manslaughter usually is homicide that occurs as a result of negligence. In fact, the most common case that you hear about in involuntary manslaughter is something called vehicular homicide. If you are voluntary manslaughter means it's a death that occurs by you failing to fulfill some responsibility or obligation. If I leave an obstruction if I leave a banana peel on my front lawn, on my front sidewalk, and somebody slips and they happen to have a very soft head and they crack their head, if it was negligent for me to do that, that might be involuntary manslaughter. If I'm driving down the road and I'm going over the speed limit and some little kid on a bike comes in front of my car, and because I was going over the speed limit, I hit that child, no one's going to claim that I wanted to kill that poor child, but nevertheless, I was negligent in a responsibility that I had. So again, we're not even getting into some of the subdivisions, but these are the main divisions. And what we're asking a jury to do is look inside the head of the person committing that crime and infer what they were thinking at the time of that crime. That will determine blameworthiness. And that's why, just in this one instance, and I haven't gone into the myriad of others, just in this one instance of homicide, do you have these two twins of criminal justice and psychology interacting and doing so without even knowing that they're in the same building.